The Supreme Court's emergency docket, also called the shadow docket or the interim docket, is for, well, emergencies. This is every time the federal government had a case there, back to the first Trump administration. And here's just 8 months into his second term. It's being used in record numbers.
Emergency applications used to be a very, very small and not especially divisive part of the Supreme Court's work. Now, this is the front lines.
Not only are there more of these cases, but President Trump is winning more than his predecessors have. And we don't really know why.
We don't know why, because with this shadowy process, the Supreme Court doesn't have to tell us. So what is the emergency docket, and why is it so controversial? CNN explains. When you think of a Supreme Court case, you're thinking of a case on the merits docket. A case starts in a district court, is appealed to a circuit court, often called an appeals court, and then it's petitioned to be heard by the Supreme Court. There's around 4,000 petitions every year now.
Then they discuss 3 to 4% of all of the cert petitions at their in-person conference. And if there are 4 justices who want to hear a case, then the case gets put on the merits docket.
From there, briefs are written, arguing each side, then oral arguments where the justices can ask questions, and then they meet privately in person to discuss the case and vote on it. They spend months writing long opinions and dissents, and then we know who won and who lost and why. A case like this will take a year or longer to get through, not including the months or years it took to work its way up through the lower courts in the first place.
It's important that the court take time when it can because it's deciding a case that will become precedent.
And that detailed explanation helps these lower courts understand how to apply it to similar cases going forward. But what happens in the meantime? Does the defendant get to keep doing what they're being sued over?
What happens on the ground while federal courts are rolling pretty slowly through that process? That is what the Supreme Court is deciding on the emergency docket.
Often when someone first sues the government down here, a district judge will issue an injunction, an order for the government to stop doing what they're being sued over. And the government can appeal that injunction all the way to the Supreme Court. They do that through an application to the emergency docket. Here, unlike a merits case, the court has to respond, and quickly.
There's no time for oral argument. There's no time for an opinion. We usually don't get a vote count, so we don't know how the justices are voting.
And they vote over email. They never meet in person to talk about it. They don't have a lengthy back and forth about what they should do.
And there isn't usually an explanation. It almost always looks like this. The application to stay, court language for stop, the lower court's injunction is granted. So in this case, the government can keep doing what they're being sued over. It's supposed to be temporary, pending a lower court's actual ruling, or even a possible Supreme Court merits docket ruling. It's often unsigned, we don't know who voted how, and rarely get an explanation as to why. An emergency application only takes a matter of days or weeks to decide. These decisions aren't on the actual case. There's no winner or loser. That's still with the lower courts. Sometimes that case does make it up to the merits docket. They often win there too, but not always.
You can win on the emergency docket and lose on the merits.
For example, when civil rights groups sued Alabama for packing most of the state's black voters into one district, the state appealed to the emergency docket to stop an injunction.
The Supreme Court said, okay, Alabama, go ahead and use your map. We're not going to say it's cool. We're not going to say it's illegal. Just go for it.
After using that map for the 2022 midterms, the case got the full merits docket treatment, and Alabama lost. They had to change their map, and it changed the next election.
It sounds like a lot of law, but it's worth fleshing out the practical consequences.
Now, this example is an outlier, as are all of these types of applications to the emergency docket. They're usually extension requests for filing briefs or petitions, and death penalty cases asking the court to stop an execution. It wasn't really designed to handle these types of cases with big nationwide consequences.
What's happened in recent years is that a body of rules and procedures that is designed to handle extraordinary cases has become ordinary.
And this increase has also caused a lot of confusion for these lower courts, who aren't really sure how to use these emergency decisions.
So in September of 2021, Justice Alito gave a speech at Notre Dame Law School where he says, oh, these aren't precedents. Well, the court has apparently changed its mind.
Justices Kavanaugh and Gorsuch recently issued an incredibly rare scolding of lower courts they felt were defying them, and said emergency docket decisions were precedent.
I get the sense that really rubbed a lot of the lower court judges the wrong way.
They're telling us nothing, and they're leaving the lower courts, the circuit courts, the district courts out in limbo as to guess what they are doing or to glean or predict what they're doing, which may be correct to do, but the truth of the matter is they could easily just give us directions on it and we would follow it.
It is completely unheard of to see this kind of public sniping between the Supreme Court and lower courts.
So why is there such an increase in applications by the government? There are a few reasons. The biggest is the Trump administration is simply doing a lot, and a lot of people are trying to stop it in court.
The Trump administration in particular has managed to get the court to be on board with the idea that it not being able to implement a policy is an emergency that causes harm to the government.
But some critics question if all of these are really emergencies, and that the court allowing so many stays just encourages more applications. Some justices have argued it's a risk to write a rushed opinion not on the merits. Some have argued that doing more of these means that they have a responsibility to explain things better.
Part of the problem is that we have a process that evolved in an era where the emergency docket was much less important, and that the justices, if for no other reason than inertia, are continuing to follow.
But as the Trump administration keeps changing the ways government works and keeps getting injunctions, the emergency docket is probably not going to get quieter.
I think the criticisms will grow louder that the Supreme Court is deciding so many important issues in ways that are having such dramatic effects on all of us with so little process and transparency.